Welcome to today's webinar. The Louisiana land loss lawsuits head to SCOTUS, examining the underlying claims in Chevron versus Plaquemines Parish and related cases. This is sponsored by the Law and Economics Center here at George Mason University's Antonin Scalia Law School. I'm Donald Koshin. I'm a professor of law here at Scalia Law, as well as the executive director of the Law and Economics Center. I'll be moderating today's discussion. The webinar is designed around the mission of the Law and Economics Center to serve as a nexus for academic research and education that focuses on the timely and relevant economic analysis of legal and public policy issues confronting judges and policymakers nationwide. All of it is centered around the belief that when judges, academics, and policymakers understand economics and scientific methodology, they're more likely to make sound business decisions, sound policy decisions, and engage in rigorous analysis that supports the rule of law and the free enterprise system. And our commitment is to developing original, high-quality law and economics research and educational programs like this one today to further enhance an understanding of economics and to provide information that's useful in legal and policy debates nationwide. We thank you all for joining us today to be part of that dialogue. Since 2013, 43 lawsuits brought by local Louisiana parishes have lingered in one stage or another throughout Louisiana, alleging that energy company activities associated with energy production and other activities caused harm by, among other things, dredging and maintaining a network of canals to access wells located on coastal and marshlands and to transport resources and energy and to serve energy needs of the region and to serve federal contracts. The lawsuits seek damages and remediation for remediation funding, I should say, for coastal land loss and increased hurricane vulnerability. Many of the acts now targeted as alleged wrongs and allegedly causing these impacts were conceived by, authorized by, and paid for by state, local, and federal authorities. Oftentimes, the energy producers being sued were conducting activities on Louisiana coastlands as direct federal contractors supporting the military capabilities during World War II, especially in the provision of refined gas, aviation gas. Consequently, the defendants have tried to remove the state cases to federal district courts, but the federal district courts have largely been remanding. However, on June 16th, 2025, the U.S. Supreme Court granted the petition for certiorari in Chevron USA versus Plaquemines Parish. And they agreed to decide in this upcoming term, which begins in just 2 weeks. And whether these defendants are entitled to remove the cases is at the heart of this. The cases were filed in state courts, and the question is whether they can remove them to a federal forum to resolve the nature of the federal rights and immunities as federal contractors. These cases raise serious concerns regarding a variety of issues, including what's the scope of tort law? What's the role of courts? What is federal preemption and how should it apply, if at all, in these cases? How are due process and retroactivity concerns affected when we have these cases being brought for long old claims? Traceability, causation, and attribution aspects that are at the heart of due process and at the heart of establishing liability also come into play. The proper role and ethical responsibilities of government litigators, separation of powers, limits of the judiciary, and others are among the topics that we may discuss today. This panel brings together a group of 4 experts following these cases to examine the underlying claims in the lawsuits, their implications, and the questions SCOTUS will consider in the case before it. So that we can reserve time for substantive discussion, I'll give only a very basic introduction to the panelists rather than extensive bios. And I recommend that you click on their names in the invitation you received from the LEC to join the webinar, or visit the LEC website at masonlec.org, where their details are located. Our distinguished panel today includes, first up, we will have Melissa Landry, who is the director of the the Pelican Center for Energy at the Pelican Institute for Public Policy. Following Melissa, we'll hear from Mike Fragasso, who is a partner at the Torridon Law PLLC firm. Then we'll hear from James Baer, who's special counsel at the Pelican Institute for Public Policy. And closing it out will be Michael Williams, who's the Solicitor General in the Office of the Attorney General for the state of West Virginia. With that, the panelists will be offering perspectives, talk a bit with one another afterwards, and then we will open it up to audience questions. If you do have a question at any point in time, please use the Submit Questions Q&A box at the bottom of your system. And please identify yourself in the text of your message and keep your questions short so that they can be readily incorporated into this virtual format. With that, I'm going to turn it over to Melissa Landry to get us started and to understand the scope and importance of the issues.
Good morning, everyone, and thank you so much for the opportunity to be with you this morning. I'm Melissa Landry, Vice President of the Pelican Institute for Public Policy, Louisiana's leading free market think tank. By taking up the landmark case, Chevron versus Plaquemines Parish, the United States Supreme Court has a chance this term to confront one of the most troubling trends in American law: the systematic weaponization of our legal system against American energy production through government-sponsored lawsuits that appear to be politically and financially motivated. Since 2013, a coordinated group of private plaintiffs' attorneys has filed 43 lawsuits on behalf of 7 Louisiana coastal parishes against more than 200 energy companies. Generally, these lawsuits allege that the widespread erosion of Louisiana's coast is caused by oil and gas production activities dating back to the 1940s, some of which were conducted under federal permits, contracts, or wartime directives. The plaintiffs' lawyers driving these land loss cases contend that oil companies should be held liable for over 2,000 square miles of Louisiana wetlands and barrier islands that have been lost to coastal erosion since the 1930s. The primary cause of coastal land loss is well known, and researchers widely agree that it is the leveeing of the Mississippi River in the early 1900s that is the main culprit. The Mississippi River, however, has no assets, and so the plaintiffs' bar is targeting energy companies instead. The firm behind the coastal suits argue that the defendants' World War II era dredging and oil production on the Gulf Coast accelerated wetland erosion. Those operations were a war effort. Those operations were a war effort obligation commenced under federal contracts to produce high-octane aviation gasoline. Sensitive to these facts, Louisiana explicitly grandfathered in those projects into a permitting regime that the state crafted for coastal oil drilling that was actually enacted in 1980. Unfortunately, the mastermind and a well-connected trial attorney who is driving these lawsuits is now leveraging his ties with politicians in Louisiana, many of whom are Republicans, in an attempt to rewrite history and essentially impose retroactive liability on the entire oil and gas industry. From the beginning, defendants have sought to remove these cases to federal court under the federal officer removal statute, but a growing split among federal circuit courts has led to essentially what boils down to a very high-stakes game of ping pong, with the coastal suits bouncing back and forth between state and federal courts for years. The Supreme Court's intervention at this point is essential, not only to resolve the circuit split and to ensure that federal contractors, especially those acting under wartime directives, are shielded from state court bias, but also to bring a much needed clarity to these coastal suits. After a $745 million jury verdict earlier this year in Chevron versus Plaquemines Parish, over 40 similar lawsuits threaten billions of dollars in additional costs. A 2019 Pelican Institute Economic Impact Report estimated that Louisiana's economy has lost between $44 million and $113 million annually since these lawsuits began. There is absolutely no question that they're have had and will continue to have a detrimental impact on Louisiana's economy. More than 2,000 jobs disappeared in just the first 2 years of the filing of this litigation, and it's estimated that state and local governments have forfeited up to $22.6 million annually in royalty revenue. That's funding that could have been used by local governments to fund schools, roads, and ironically, additional coastal restoration efforts. As you will hear a lot more about from my fellow panelists today, the structural problems underlying these lawsuits are even more concerning than the economics. When private lawyers are empowered to assert legal claims on behalf of the government while simultaneously funding the political campaigns of the elected judges and justices who decide them, the appearance of impartial justice is compromised. And that is exactly what is playing out here. According to state campaign finance reports, the outside counsel who are driving these lawsuits have collectively contributed over $3.5 million to Louisiana judges and justices between 2010 and 2020. And it is this fact that really underscores the importance of the federal officer removal statute. In fact, I would argue that this is exactly what the federal officer removal statute was designed to prevent. That is, local tribunals sitting in judgment of federal contractors, especially where those tribunals have direct financial incentives to rule against against defendants. The energy industry has been a partner to Louisiana state and local governments, as well as the federal government for a very, very, very long time. And they have invested tremendously in Louisiana at the state and local level, and including many, many millions of dollars in voluntary projects that they have funded to support coastal restoration efforts. And I would argue that it is those voluntary efforts that have been far more beneficial to Louisiana's coast than these lawsuits ever have been or will be. So with that, I will yield.
Thank you so much. Turning it over to Mike now.
Thank you. Thanks for hosting this. Thanks for having me. As Melissa said, these cases have been going on for over a decade. There are 43 of them brought. She also noted the parishes down in Louisiana brought them by outsourcing the lawyering to private plaintiff lawyers who are probably getting paid for this on a contingency basis. So you have these parishes going after the oil and gas defendants in a way that are just going to massively enrich these private parties. The state itself eventually did get involved in the suits too, in part to preserve cases where the parishes would try to withdraw. A problematic aspect of that is that the state entered into a joint defense agreement with the plaintiffs that forswears all defenses, even if they're potentially valid. So if, say, Chevron were to raise a valid defense in this litigation, the Attorney General of Louisiana won't countenance that valid defense. And of course, it's an Attorney General, right? This isn't a private party simply suing. This is, there's a broader conception of justice that probably should be involved if an Attorney General is involved. But they contractually got out of that with a joint defense agreement. Now, it's the current case at the Supreme Court is the Plaquemines Parish case. That's the one that has gone to judgment. It's a $745 million judgment against Chevron. It's important to note that the way these suits work is the defendants are potentially liable for all of the land loss in the parish for each of their different violations in the parish. And this is just one of 10 or 11 such suits against Chevron in Plaquemines Parish. So the judgment here is $745 million. But in Plaquemines Parish alone, you could be looking at tens of billions of dollars in total exposure. So it's just catastrophic damages that are being thought about. The core problem here is that Chevron and the other defendants are thought to have violated a law that's called the State and Local Coastal Resources Management Act, or SCORMA, that went into effect in 1980. It was a Louisiana law that was passed under the auspices of a federal law, the Coastal Zone Management Act, that sort of encourages states to come up with good coastal management programs as part of getting federal funding. As I said, SCORMA went into effect in 1980. And as Melissa said, a lot of the activities here go all the way back to World War II. In particular, a lot of the activities that supposedly caused the land loss are well before 1980. The World War II stuff is particularly interesting because it was part of the necessary actions taken by oil and gas companies under the direction of the Petroleum Administration for War to get aviation gas, or avgas, which was a critical tool in giving us a competitive advantage over the Axis. In terms of the litigation, the brief by Bill Barr and Judge Mukasey has a lot of good information on this, as well as the one by retired General Myers. And the fact is, since these companies were engaged in activity under the management of the Petroleum Administration for War, they were federal contractors essentially. And so I'll get into it in a second, but that's the heart of the case at the Supreme Court, is whether or not that therefore puts them in a federal forum or a state forum. Going back to the pre-sklerma activities, though, that the defendants are alleged to have engaged in, as Melissa said, it's retroactive. They are being held liable for activities that didn't, there wasn't any legal prohibition on them while they were engaged in them. It's particularly unjust in that sklerma sets up a permitting regime, not necessarily an enforcement regime. And after sklerma was in effect, they couldn't have gotten the permits necessary to obviate their liability under this theory. The brief from the American Tort Reform Association is very good on this. I'll just quote some of that. A government witness's trial testimony about longstanding agency practice related to sklerma touched on this. Specifically, the head of the state agency responsible for administering sklerma testified that the agency had never in over 40 years interpreted sklerma to govern activities commenced prior to its enactment. He admitted that the agency had, quote, never once regulated an activity that began prior to 1980 or, quote, issued a coastal use permit for an activity that began before 1980. He admitted that he was, quote, not aware of anybody at the agency communicating to industry that they needed a coastal use permit for activities that were commenced before October 1st, 1980, when sklerma went into effect. In other words, they are being held liable for activities that they couldn't even have remediated if they wanted to. It's the regulatory equivalent of the story Justice Scalia used to tell about Nero putting the laws up on a tall pole so that they'd be hard to read and easy to transgress. Here, at first, the state trial court agreed with the defendants and granted partial summary judgment on this score, saying that the pre-sklerma damage activity wouldn't count. It then reversed itself a month later without any explanation, which goes to Melissa's point about the danger of having local tribunals decide these cases for local benefit. Stepping back, again, as Melissa said, these cases have had a significant effect on the Louisiana oil and gas industry. 25 years ago, it was a third of Louisiana's economy. Now it's 14%. These suits began in 2013. Since then, oil and gas extraction jobs have fallen by 41%. Also, since 2013, Louisiana crude production has plunged by 57%. Now, compare that to Texas, where over the same time period, crude production has surged by 123%. And it makes sense, right? Why would you do business in a state that is, on one hand, essentially extorting you and is saying that legal actions today can become illegal in the future and there's nothing you can do about it and you're going to have to pay for it then? It makes it a terrible place to do business. Now, the case at the court this term, of course, only applies to a piece of this legislation. It's the Plaquemines case, which is the one where there is a jury judgment against Chevron, and they rendered a verdict. But it's about whether or not it belonged in state court or federal court under what's known as the officer removal statute. So, big picture, if you are an officer of the United States or operating under color of an officer of the United States, you get a federal venue rather than a state venue. And it's, as Melissa said, to prevent states from sort of going after federal agents or federal officers that they don't like what they're doing. Congress amended the removal statute in 2011 to expand it. In many ways, the Fifth Circuit opinion below kind of referred to the previous, more cabined officer removal statute before Congress expanded it. Judge Oldham does a very good job explaining how the removal statute is actually considerably more expansive and should apply to Chevron here. The Solicitor General of the United States also made a very good case for that in his brief at the Supreme Court. And the fact is that it matters. I'd again refer you to the brief by General Barr and Judge Mukasey, as well as the brief by ATRA. Just the number of irregularities and decisions by the local court, the parish court in this instance, that just look like home cooking. It's fairly remarkable. It's not just, reversing course on the retroactivity ruling. Also, other odd things like not allowing Chevron to voir dire a woman whose husband works for the parish that's bringing the suit, calling that unfair. There's just a catalog of these things. And again, I'd refer you to the bar brief and to the ATRA brief to see more of them. And it's a fundamental problem of plaintiff-friendly elected judges in Louisiana hearing cases worth billions of dollars for which the juries stand to benefit because it's all local. And that's why it matters to get it into federal court. If you get this case into federal court, as the Solicitor General said in his brief, it doesn't necessarily end the suits, but I think it would make it fair. The judges in federal court in the Eastern District of Louisiana, they were appointed with the advice and consent of the Senate, appointed by the president. They're not elected with the assistance of plaintiff counsel. I used to work in the Senate. We have Senator John Kennedy from Louisiana. He's very committed to ensuring that the judges who sit in New Orleans are competent and fair. The fact is that if it's in federal court, the jury's not just going to be a jury from the parish. So essentially ruling on whether they get billions of dollars for their local community. They're drawn from around the district, so that there's more fairness there too. And then also, on appeal, it goes to the Fifth Circuit, which is a very reasonable court that has lots of experience in these kinds of oil and gas cases and in these kinds of complex questions of constitutional law, due process, fairness in terms of retroactivity, statutory interpretation, all of that. The Fifth Circuit's a great place to have it. So that's where it stands, and that's what's going on. And again, thank you for putting this together, George Mason, and thanks for being on the call.
Great. Thank you very much, Mike. And James.
Thank you so much. My name is James Bear. I'm the special counsel at the Pelican Institute. I helped launch the Pelican Institute Center for Justice back in 2019 before doing a stint in the federal government. And I was able to work on and file the our Pelican brief, as you might call it, for this particular case. So painful joke. So I kind of wanted to walk through a little bit more detail. I'm going to play off of the discussions that have been provided by Mike and by Melissa, and I'm going to walk through kind of what our argument was, which is very appropriate for this audience. The Law and Economics Center ensures that you all are not just legal nerds, you're also economic nerds. And a lot of our focus essentially was a policy focus on why the economics of this simply don't make sense. Although the economics make sense for these fee-shifting lawyers, the economics don't make sense for the state. When you kill the goose that lays the golden egg, when you think you can extort these companies, they end up not acting in the state, and they end up leaving the state and going to friendlier venues. And that's kind of the thrust of our argument and our research on this issue. As Melissa said, I'm not sure if I can use the share function here. Oh, I see. I've got to request it from the moderator. I wanted to kind of walk you through a little bit of our analysis. Let's see if this works now. Great. Are you all able to see that?
Yes.
Okay. I wanted to kind of talk through, first of all, kind of this land loss issue. Let's see if our first point in our brief is basically on our privatized enforcement issues and the due process that are presented by that. As Mike has pointed out, and as Melissa has pointed out, Louisiana, unfortunately, through the joint prosecution agreement, has deferred to these fee-shifting lawyers who are going to the parishes and gathering these cases. And they stand to collect, obviously, hundreds of millions in fees, while the state committed not to endorse any substantive defenses. And from our perspective, this is a major issue that was identified by Hamilton in Federalist 80, which is that when local juries cannot be impartial, when local court tribunals cannot be supposed to be unbiased, there's an opportunity to move those towards the federal side. And as Mike pointed out, as somebody who worked in the Senate, we believe that would be a fairer outcome here than these judges, the local judges who have received numerous campaign contributions from these trial lawyers and created the structural bias. To the second point that we make in our brief, it's really about the harm to the citizens and to the economy. And there's multiple different facets that this plays out, but essentially our economic research points out that the state lost after the beginning of this litigation lost $44 to $113 million every year. And the analysis, which I was going to share, and I'll point it out over here. And if you go online, you can find this, but we have basically an economic analysis that shows that the state lost significant, that 53 to 74 fewer oil wells were drilled offshore after the beginning of this litigation, that royalties for the state went from dropped by 8.9 million per year to 22.6 million per year in royalty revenue, which is ironically less than these oil companies actually even stand to gain because their profit margins are thinner than those royalties. So the state itself has lost more money through this litigation and through encouraging this than it would if oil and gas had increased in the state. The estimate of these economists of the minimum economic loss was 44.4 million per year, and a decrease of more than 2,000 employees across 4 occupations in the state's oil and gas industry. And this was not just because this was a weak period for the oil and gas industry. The economists who did this analysis analyzed what was going on federally and in Louisiana before 2013 and after 2013, and were able to rule out some of those other potential explanations for why the state was suffering. Now, that sort of suffering that we saw in the state when these began, you can imagine that on steroids now. And Mike pointed out some of the statistics and people going to Texas and other places. But when you have one case that's $745 million verdict, and you're facing numerous other ones in numerous other parishes, you can see quickly why folks would choose not to do business in the great state of Louisiana. And Mike pointed out the challenge of kind of local tribunals having a vested interest in this as well. Some of our parishes in Louisiana are extremely rural. The Cameron Parish has fewer than 5,000 residents. There are more cows in Cameron Parish than there are people. And so you can imagine somebody, Chevron going before a jury there in a parish where if a multi-million-dollar verdict comes down, each of those individuals stands to gain quite a bit. So we also point out some of the challenges in the settlement approaches. Freeport-McMoran attempted to propose a settlement. It ultimately didn't end up working out. But the settlement approach in Freeport-McMoran, which Pelican also wrote a report on, was not a settlement proposal that was going to lead to coastal restoration or to help the state. It was sort of a cleverly structured system, which ultimately would just profit the attorneys primarily. And so that's a major concern. Ultimately, several other oil and gas companies did settle, but we don't ultimately know what happened. Those were confidential settlements, but they're simply seeking to kind of avoid some of the worst of it by resolving these cases. None of these settlements in the best interest of the people of Louisiana. And finally, ultimately, many of the other briefs in this matter, and Mike's absolutely right, the American Tort Reform Association brief goes into detail in all the due process violations in that state court and is well drafted. But ultimately, federal jurisdiction matters because this is spreading beyond Louisiana. We've got climate change lawsuits everywhere. We've got other states where they're going after disfavored industries, whether it's tobacco or guns or whatever else. We've got the possibility of retroactive liability for these disfavored industries. And you could see this spreading. And the system that the founders designed and that Congress intended was to allow those folks to go into a more fair, impartial federal tribunal to resolve the issues. So that was our piece in this discussion, but happy to continue the discussion here.
Great. Thank you so much. And to remind the audience, if you have questions, please use the Q&A box at the bottom of your screen. Type the question in, identify yourself, and at the conclusion of the intra-panel discussion, we will pose your questions to the entire panel. With that, I will turn it over to Solicitor General Williams.
Thank you. So I'm going to address maybe the most obvious question, which is why is West Virginia at all interested in what's happening in Louisiana? And that's because we really view this as a national issue. It's not just a local issue. It's not a state-specific issue. In some ways, what's happening in Louisiana is a reflection of a broader national trend as to the energy industry in general. At the federal level, we've seen some really encouraging things for traditional energy producers. We've seen President Trump obviously issuing a number of executive orders that when it comes to declaring a national energy emergency or unleashing American energy, these are measures that really put the full weight of the federal government behind traditional energy producers like coal, oil, gas. really trying to make sure that those interests remain a central part of America's success. President Trump has also voiced serious concern about state overreach and how the maybe overly aggressive and overly expansive approaches undertaken by certain states, either through regulation or litigation, have impaired those federal interests. And so I think, unfortunately, what's happening in Louisiana is exactly what President Trump has been talking about. We've seen these kind of play out in a variety of fora and in a variety of different ways. Some states, for instance, are filing climate change nuisance suits, basically trying to hold traditional energy producers responsible for serious weather conditions and flooding and things that they attribute at least to anthropogenic climate change. Other states are actually passing laws, like New York and Vermont are passing what they term climate change Superfund acts, where they try to retroactively they impose multi-billion-dollar fines retroactively on lawful activities that they believe are the impetus for climate-related harms and injuries within New York and within Vermont. We've also seen states like Michigan going after other parts of critical energy infrastructure like pipelines, saying effectively these pieces of infrastructure should have never been built in the first place, and we need to depermit them or bar them or declare them nuisances and stop their operation, effectively saying, oops, we got it wrong, we want to go back and try again. And in the meantime, we're going to make energy producers pay millions and billions of dollars. Unfortunately, the Louisiana case fits hand in hand with many of those strategies, and it shows that this isn't really a red state, blue state divide. Certain states have made a judgment that they want to pursue and extract from traditional energy producers funds to subsidize either strained local governments or pet projects or strained balance sheets, whereas other states have made the decision that it's in their broader interest to preserve those traditional energy interests. And I think that's why you see the sort of unusual political divide here, where you do have a certain number of red states, West Virginia included, coming in and really voicing concern about what is happening in the local state courts in Louisiana. It's also a little bit unusual, I'll say, to see this playing out in Louisiana because Louisiana itself, under certain Republican governors, Republican attorneys general, had sometimes voiced a pro-energy platform. In fact, we often partner with Louisiana on certain pro-energy initiatives. We challenged the Biden liquefied natural gas ban pause, for instance, with Louisiana. But unfortunately, it seems like the temptation, I guess, to collect some funds has grown a little bit too great. And so Louisiana has adopted a little bit of a conflicted energy position in that way. I'll say that we have some serious concern, in part because we view this as an escalating risk. As one state begins to adopt an approach where they collect hundreds of millions of dollars, other states see that and think, oh, great, well, we can do the same. And then you have sort of a spiraling effect. And we saw this in the climate Superfund context where Vermont passes an act, then New York passes an act, and all of a sudden 20 other states are considering the same. If what happens in Louisiana succeeds, if they're able to use local fora to effectively extract millions and billions from significant producers, it seems reasonable to expect the same to happen in any number of fora. It's just going to be the case that politicians are going to either face local pressure to adopt the same strategy, or they're just going to assume the mantle themselves because they're looking to solve difficult fiscal problems. And it seems like a solution to those problems. We also, again, we recognize that with the federal approach that's currently being taken by the Trump administration, some states, I believe, are just getting frustrated and view energy regulation or environmental regulation as a vacuum that needs to be filled. And instead of sort of supporting the deregulatory efforts at the national level, they want to kind of rush in and impose some of those same consequences and same effects by way of either litigation or direct regulation. So again, because the Trump administration is taking a supportive approach towards traditional energy resources, we would expect, unfortunately, if what happens in Louisiana works, we're going to see more of those states step in and employ those same tools. There's been kind of an attempt by the state of Louisiana in particular, and some of its messaging, to try and distance what they're doing from some of the traditional climate change nuisance suits, for instance, and maybe the New York and Vermont climate change acts. I guess the most coherent distinction I've heard, which candidly, and I only speak for myself, I'm not speaking for the state of West Virginia, but candidly, I don't find their distinction convincing, is they have tried to distinguish on the basis of this causation idea. Louisiana basically is taking the position that the nuisance suits are improper because it can't really be shown that the particular weather-related harms are directly caused by the traditional energy-driven operations that everyone concedes were lawful at the time. And they say, well, the difference in Louisiana is we can directly attribute the harms on the coastline to the activities that were perhaps lawful in the 40s and 50s, but nevertheless, the activities that they believe caused those shoreline effects. The reality is that's just not the case. The evidence, in fact, shows that there are several other, not just potential explanations, but direct explanations for some of what you're seeing along the Louisiana coastline. The reality is that extreme weather events, for instance, we're all familiar with what happens in Louisiana, has caused some of these consequences. The federal government's choices when it comes to the way in which they manage the Mississippi River, for instance, and some of the water flows within the Mississippi Delta region have had direct and identifiable effects on some of these areas, and maybe even are more of an explanation for what we're seeing than the particular activities that Louisiana has chosen to go after. So in many ways, the causation problems that we see in the climate nuisance suits or in the Climate Change Superfund Act context are repeated in the Louisiana suits. So Louisiana, along with some of our West Virginia, along with some of our partners, came into the Louisiana suit just to say that, look, if these are the fights that we're going to be having, then at least they need to be fought out in a federal forum, because the interests that are invoked in litigation like this are substantially federal and national interests. And a decision that happens in a single parish in Louisiana, especially when repeated 43 times, is going to have collateral consequences for our entire national energy system. And that includes West Virginia's role, it includes Texas's role, it includes all sort of traditional energy producers are going to be implicated by what happens in Louisiana. So as we saw it, it really was a straightforward question or answer to the question, which is that given that this is a federal interest, it really does fundamentally belong in federal court. And as we explained, we filed an amicus brief with the Supreme Court. We explained that we thought the Fifth Circuit took an unduly narrow view of the removal statute and enforcing those cases back in Louisiana state courts. West Virginia, unfortunately, has some experience with challenging circumstances, I'll say, in state courts. We are familiar with the influence that can be had politically over state court decision makers. John Grisham based one of his novels on some things that happen here in West Virginia. So we unfortunately are very sensitive to the ways in which state courts, although important players and they offer outstanding jurists and they play an important role in our federal system. But when it comes to certain issues that implicate fundamentally national interests, it's just the incentives are just stacked in such a disfigured kind of way that it has to be the case that federal courts step in and play the decision-making role. So ultimately, that's why we got involved, is we want to reconcile the disconnect that we see between what's playing out in Louisiana and then what's playing out at that national level and where we think our interests lie. So with that, I'll turn it back over.
Great, thanks. Before I turn it to the panel, I have a couple direct questions for you, Michael. One is who joined you on that brief, and can you tell us where what you expect next in the case?
You're making me do the memory test here. So who joined us in the brief? We've got Alaska, Iowa, Georgia, Missouri, Nebraska, and Oklahoma. I think it's not surprising that some of the larger energy producers like Alaska and Oklahoma are with us on that. But I think it's also notable that folks who might not be viewed as oil and gas states saw that this really has a significant effect on their energy markets and their consumers as well. When it comes to what's next, you're saying in the
docket, I mean, what milestones should people be looking for next?
So you're going to be looking for a response brief that's going to be coming in from respondents on November 13th. Then there'll be some reply briefing, and then of course it'll be set for argument. I don't know yet who's going to be coming in on the side of the plaintiffs in the state of Louisiana here. Candidly, I had been told beforehand that the Trump administration was going to be filing on Louisiana's side, which I was skeptical of to begin with, but obviously didn't happen. So it'll be interesting to see who's on the bottom side, on the amicus side as well.
Great. Thank you so much. So I'd like to turn it over to all the panelists to reflect on anything that you heard from each other and offer any supplemental remarks. Anyone have something they'd like to add? Mike.
Yeah, I had a sort of a question for Michael based. It was a very interesting presentation, and I especially liked pointing out that you can't really separate what's going on in Louisiana from the broader climate lawfare agenda. And you guys know that as well or better than anyone, having sued in New York against the Climate Superfund law that they passed up there. But I was interested, you pointed out that it's not just ideology, and this is part of why it's all connected, in that even in these blue states, they see these companies as piggy banks, right? And it's not just about getting them to stop what they think is bad behavior relating to global warming, it's also to get their money. What role do you think the plaintiff bar plays in all of this, right? Because down in Louisiana, we've got some very connected plaintiff lawyers who are driving a lot of this. Nationwide, you've got the Scher Edling firm that seems to be involved whenever you have one of these climate lawsuits. How much of it is it? Do you think it's fair to say that it's not just states and localities looking to pad their, bottom lines, deal with fiscal holes and going after these companies, but it's also putting aside whatever the perceived moral benefit of going after these oil and gas companies is, people are just getting rich off this, right?
Yeah, I think all these things kind of work hand in hand, right? So you kind of create a perfect storm where you have a state maybe that has a lack of traditional energy interests, or maybe they perceive at least a declining traditional energy sector, which some people describe Louisiana as. I take issue with that characterization, but if you have kind of a right political environment, then I think it creates the space for plaintiffs' lawyers to come in and say, hey, let's do this by setting up a liability scheme, and then we can take our cut, and then they can be very aggressive about it. And then sort of everybody gets to pocket off that, because you have the plaintiffs' lawyers benefiting, you have all the political players, right? All the elected political players get to then take their portion. And then the electeds get to say, hey, New York, Vermont, Louisiana, we're taking all this money from out of state. You're not having to pay anything, and we're going to get to build a brand new road or a brand new school or a brand new whatever. And it looks like a windfall. Not, of course, understanding the trade-offs, which I think Pelican did a very nice job of explaining, that ultimately you're just stealing from yourself, because any kind of reasonable business person is going to try and completely sever any connection they have with your state in an attempt to avoid that kind of extreme reliability. But yeah, I think it's not as simple as just one bad governor, one bad mayor, or one bad county parish council. It really is a number of sort of interested actors coming together to unfortunately create a very bad result.
Here at the Law and Economics Center, we often stress that you should be identifying individuals' self-interest as well as incentives. And I think that you put those two things together and you can predict what the answer to that question might be. Other thoughts on each other's remarks or questions to the panel?
Yeah, I would just, building on the theme that several other panelists talked about, highlighting, unfortunately, the fact that Louisiana is not alone. While we call them coastal suits and not climate change lawsuits, they are essentially, very similar in approach, and also certainly in desired outcome. Actually, on the same day that we filed James's beautifully written brief, the Pelican Institute also joined the Manhattan Institute and others in a brief in Suncor versus Boulder County. And there, we argued that Boulder's attempt to apply Colorado's state tort law to regulate global greenhouse gas emissions violates constitutional principles of horizontal federalism. And allowing that lawsuit and others similar to it that you all have already pointed out have been filed in New York and in California and other places. Allowing such lawsuits to continue would empower one state to essentially dictate energy policy for the entire nation. And the Constitution wisely grants that authority to Congress, and certainly not to state and local government. So it is, unfortunately, an issue that is not unique to Louisiana, and apparently not going away anytime soon, unfortunately.
So to situate this for the audience, and I think it's been implied by the comments, but if the audience is not familiar with sort of the dozens of climate change lawsuits, we can generally characterize them as saying that there's alleged environmental harms that have occurred as a result of climate change. That is analogous here to the claim of the land loss. These things happened decades, if not hundreds of years ago, and that actors who were acting at that time, even though the activities were not unlawful at that time, should be responsible for remediation efforts. So similar to the, analogous to here in Louisiana, that there should be remediation in these cases. And so a very similar theory, you just kind of plug in slightly different wording, and it's all about retroactive liability for previously lawful acts, and an attempt to create a fund that can purportedly be used for new public projects that would otherwise not be capable of being funded, but for the lawsuits. I think also, and this is my tee up to a question to all of you, but maybe to Michael as well, since you brought up the causation issue, is that there are only certain potential contributors to the environmental harm that are brought into these lawsuits, correct? And so the allocation, even if you could say that there is some, if you were to concede that there's some level of causation, or that there's a more direct link of causation in the Louisiana cases Louisiana tries to claim than the general climate change cases, they're still not all the contributors in front of the court, right? And so how are the courts in these cases dealing with allocation of liability? Because due process would require that you can't say that there are thousands or millions of people contributing to a problem, or the problem has different confluencing factors, such as, natural effects of storms in Louisiana, and maybe some kind of human interaction as well, that needs to be teased out, because you can't, in our system of justice, you can't normally just say, well, we're going to bring in one person and make them responsible for all of the liability, especially if there's not a contribution action afterwards where they can go and sue the other contributors to these. So any thoughts on that allocability issue, and how that should be considered in the overall fundamental fairness conversation?
Yeah, I think actually I just brought up this part of their brief. So the causation issue is a huge issue. I don't know if you're able to see this. Can you all see the screen here?
Yes, we can.
So first of all, here's land loss, right? So we have experienced land loss in Louisiana. There's no doubt about it, right? We've had land loss from 1932 to the present, and then we've got land loss projected for the future. This came up in the Plaquemines trial, and the court ultimately threw out these other potential rationales and allowed the jury to basically determine that Chevron needed to pay for all of this. The court's ruling on causation in its entirety constituted essentially one paragraph, denying Chevron's attempt at a directed verdict on that issue. And fundamentally, that shows the due process challenges here, in that there's numerous reasons for land loss, and to hold one individual, one group, one entity responsible for all of it shows how unfair it was. And the vast majority of the damages in this case came from that land loss determination.
Any other thoughts on that? I'll also note too, as you're thinking about whether to chime in, I'll add to the audience that we do have several questions. I'm going to turn to those in just a couple of minutes. We will have time probably for some more, so feel free to continue to populate the question pool. And I think that maybe there were a couple more remarks on the last question before we turn to the audience questions.
I was just going to say, I think this shows a little bit of the danger in, again, things turning on quirks of state practice, because the ways in which fault is allocated or apportioned varies so wildly across states. I was talking with someone yesterday about this exact question, and I was talking about how in Michigan there's a notice of non-party at fault structure, where if you're a defendant, you can file a list of everyone else who you think is responsible. And then on the verdict form, the jury is actually asked to apportion fault to those actors who aren't present. There's an empty chair, but at least they have an opportunity to consider, who else might be responsible for the injury for which you're being held responsible. But the reality is that a lot of states don't have something quite like that. Sometimes it can be more complicated. Sometimes your only option is a contribution action. It just depends. And some states have made a deliberate policy choice to kind of make everybody jointly and severally liable. And then you're talking about hundreds of billions of dollars of liability for the sole defendant who might happen to find himself unlucky enough to get served and hauled into a local court. So that again goes exactly to why we view this as a national issue. Those apportionment and allocation issues are very real, and should kind of we should kind of all understand the rules of the game in a better way than we're able to based on local law.
In Louisiana in particular, they traditionally, as I understand it, have very unusual and old-fashioned comparative fault rules that I think are currently being changed by the legislature. And so you have these giant suits that are going through now, where if you assume the plaintiffs are correct, there is some sort of comparative fault component to it. Who knows what the rules are? As you said, the rules of the game are being changed sort of as it's being played. And Melissa, I like that you brought up the Suncor suit, even though it's not this case, and the importance of horizontal federalism in it. It seems to me that to a certain extent here, but then especially these other cases, that's the key to what's going on here. And the thing that the court really needs to grapple with is really asserting horizontal federalism as a thing. And I think if you read the Solicitor General's brief in that case, it was very impressively handled by them. And hopefully that's an issue that we see going forward.
And before we move off that, can you, for the audience's benefit, can you explain where the Suncor case, where the Colorado case is at this point, the Boulder case?
They're seeking cert, so they lost in front of the Colorado Supreme Court. There's some odd quirks of Colorado constitutional law that determine whether or not this is actually a final judgment that's appealable. And so that's one of the issues that's sort of going to be before the Supreme Court. It probably is appealable, but they're seeking cert on it. There's, I think, been a lot of good support for them to get cert on it because the Supreme Court just keeps dodging these climate lawfare cases for whatever reason. And they're going to have to take it at some point. Frankly, it's better that they take it now when we're only talking about billions of dollars on the line rather than hundreds of billions of dollars if any of these states really get going on these cases.
Great. Well, let me turn to some of the audience questions. And Victor Maddox has a bit of an explanation followed by a question. So I'm going to read through this and invite any panelists to respond. Victor says that we've seen private plaintiff lawyers signing up dozens of counties in Kentucky as clients in the opioid litigation and hundreds of counties nationwide, signing contracts from 25 to 40% contingency fees, making it difficult to settle on a global basis because the cost to county officials were effectively captives of their counsel. Lots of resulting delays and costs in fees and questionable benefits. State AGs, Victor claims, were already representing the interests of the states. So I assume what he's saying there is that was it really necessary to have these separate suits if the state AGs exist as a way to do that? And Victor's question continues then, the Louisiana cases seem to extend that model and likely it will spread. How can states eliminate this private model and regain control of the process? Any thoughts?
Go ahead, Mike. Sorry.
Yeah, I mean, I think you have to distinguish between a few things. There's not necessarily anything wrong with states using private attorneys. I'm currently working on behalf of a state on another matter. If they provide a certain capacity and expertise that the state doesn't have the resources to build internally, right? I think that's probably different from what you saw in the opioid cases. It's different from what you're seeing in Louisiana, which is more like this concept of swarm litigation that came, I think, really out of the tobacco cases more than anything, where lots of states partnered with not just private lawyers, but very prominent plaintiff firms and outsourced a lot of the work to them and created situations, whereas Vic points out, you have all these different counties bringing the suits in the opioid cases. It makes it impossible for a defendant to actually deal with these things in court. So it just forces settlement, and it forces settlement in ways that enrich the plaintiff lawyers. That strikes me as different from the sort of traditional private contractor for an attorney general. And that seems bad. And the other issue is one that James and I talked about a little here, control, right? If state attorneys general are hiring private lawyers with good reason, they should retain control over what the private lawyers do. They are agents of the state at that point. The problem in the Louisiana case is that the state has forsworn any such control over the private lawyers who are bringing these suits through their joint defense, their agreement between the two parties. And I suspect opioids is probably something similar. And so those strike me as the distinctions that are worth bearing in mind and make these situations bad.
How unusual is it to make a pre-commitment to not assert any defenses prior to knowing what the defenses might be?
Seems pretty unusual to me. It doesn't strike me as particularly, sound legal practice. You normally want to determine what the defense is before you respond to it, whether you should respond to it. Again, especially for an attorney general, right? There's, as James pointed out at the outset, there are broader commitments to justice at play when you're representing all of the people of the state.
Other thoughts on the audience question or on the pre-commitment issue? All right, turning to another audience question then. Is Louisiana a particularly difficult jurisdiction for liability? Has it been identified as a place of concern in the civil justice environment in the past?
It has, sadly, and Melissa can speak to this, but for 10 years we've been on the list of judicial hellholes. So we've reached the point of being an everlasting judicial hellhole, according to kind of the tort reform groups.
And how do you get that designation? How does the state get that designation?
Yeah, there's certainly no question that there is a persistent perception that it is difficult for some defendants to get a fair shake in Louisiana courts. And certainly there is a lot of room for argument about whether or not that is actually the case. But certainly there is no question that that is the perception that is broadly held, both inside and outside of the state. The reasons for that. Louisiana has a unique system, so yes, we just have lots of unique laws, and I mean our justice system, civil justice system as a whole is just unique from every other state. Certainly, many very large nuclear verdicts over the years that make widespread national and global news. Certainly, the very large verdict against Chevron in this case was one of many examples. And the fact that we have a system in Louisiana where we elect our judges, and by and large, the plaintiff's bar is very frequently plays an outsized role in those elections. So I think there's a myriad of factors that contribute to the perception, and whether or not that perception is fair or not, I think can be debated. But there's absolutely no question that there is, and it has been for a very long time, that perception.
So Nina Farah asks whether there are any similarities with the climate change liability lawsuits, and I assume that means both the. I think we could probably break it out into both the lawsuits that are pending against, say, the Superfunds, so against the legislative act, as well as the climate change tort suits across the country. Is there any way that this Supreme Court decision in Plaquemines would affect those other types of suits. My initial inclination would be that since Plaquemines at this stage is not going to get to anything other than the removal jurisdiction, that probably isn't immediately going to have any effects on the climate change liability cases, because the court won't have an opportunity to talk much about the merits of the cases or demerits of the cases, or the causes of action. But maybe I might be missing something. Is there anything, maybe even just sort of in terms of a trajectory that we might be able to predict if the court decides one way or the other on this case versus the others?
Can I politely disagree with you?
Sure.
I think honestly, depending on how broadly they write it, I think it could actually have some fairly direct effects on the climate change tort suits, at least, because some of the defendants, particularly early on, were trying to remove on a federal officer removal basis. And so if they really do reevaluate the test and say, no, we mean it, it's a relatively broad standard now after the 2011 amendment, I suppose, I think you might see defendants give that another run. They were, I believe, largely unsuccessful in that. But maybe that comes back to life again. So there's one direct impact. I think that the more indirect impact, though, it really is to the extent that this is a signal that these cases are of sort of national interest and national concern, then that's going to make judges more reluctant to sort of play ball on these, like, let's just send it all to state court and wash our hands kind of approaches that we've seen from a few federal courts lately. I mean, the related Enbridge case that I was kind of alluding to earlier, it felt a little bit like that from a relatively conservative panel on the Sixth Circuit. So it might be enough of a message in the Supreme Court to say, no, we really want these issues in front of federal courts.
Excellent, and always happy to be disagreed with. I was presenting what I think might be the immediate reaction. I'm glad to see that there is something we need to be considering. And just to give us a sense, when the courts did consider, or when the Supreme Court was petitioned for to resolve the federal officer removal cases, that was just the court letting it stand, correct? The court is not opined on that. Am I correct?
That's exactly right. Although, if I'm remembering them from memory, I think most of those courts said that the early iterations of the climate change tort suits were focused on like marketing activities. Some of them were brought under consumer protection theories. And I think the court said, well, even if you were doing things under a federal framework, your marketing activities weren't under that federal framework. So I think if the court says no, relating to is broadly relating to, I think the oil companies in particular have a pretty good argument that marketing is related to the production, right? So they might make that argument again.
Other thoughts on the impact of this decision at the Supreme Court on sort of downstream impacts of to other climate cases?
I agree with everything Michael said, and I think another thing to consider is just, I think there's an impact of the court taking this case in terms of showing that it is willing to look at climate cases. Again, there's just been a series of cases where they've refused to take them, kind of depressingly. And now here you finally do have one where it's on a technical issue. It's sort of a technical Fed court statutory interpretation thing. But it is a blue chip climate case, essentially. And they're willing to hear it. And I think there's value in that alone. But you know, if they get it right and reverse the Fifth Circuit, I think Michael's right that officer removal initially in a lot of these climate cases was sort of the silver bullet that a lot of oil and gas companies were looking for, and they weren't able to get it. So anything that helps them get that is probably good.
So Keith Criddle asks, why isn't 7 counties versus Eagle County applicable here? Any responses to that question?
I'm sorry, what is the question again?
Why isn't 7 counties versus Eagle County applicable here?
So I feel like I'm doing too much of the talking here, but I think the short answer is that case mostly concerned the responsibilities of federal agencies to prepare environmental impact statements under NEPA. This is a little bit different. I mean, it sort of relates in that how far down the stream can we go, I guess, is sort of a similar question, but that's sort of a distinct statutory framework and a distinct responsibility.
Great. We have some potential room for other questions if people want to enter them into the Q&A. Before I turn back to the Q&A box, though, I do want to ask one of my own, and that is, can someone let us know what's the status of all of the cases that were pending at the point of the CERT grant here? Have there been stays in any of these cases? Are they ongoing? What do you expect next in the various parish cases? Are they sort of proceeding full speed ahead, or are there any particular inflection points that we should be watching for where things might change?
Yeah, I would just point out it is my appreciation that the district court in the Plaquemines case was made aware that there was this pending appeal before the U.S. Supreme Court, and there was a decision made to move forward with the trial, even while the question was before the U.S. Supreme Court. It is, my further understanding and appreciation that there are a number of other cases that are, that are scheduled for trial. And so, if history serves as provides the precedent, I think it's reasonable to expect that those will move forward. And how the Plaquemines verdict and in any other cases that move forward before the U.S. Supreme Court issues a ruling here, how that will ultimately impact what has moved forward in state courts. I mean, we just kind of remains to be seen at this point.
So my next question is a little bit broader for the panel as we get close to our ending time here. What is the appropriate role for courts, and why is a judicial proceeding perhaps different than a regulatory process, and how is that being tested in these cases? Are we seeing a transformation of how courts are used, and what's the danger in that if we are?
Yeah. I will, give my fellow panelists some time to talk about this, but I just wanted to, to highlight here a point that we haven't touched on yet. But Louisiana energy producers, the very folks who are being targeted by this litigation, are the #1 private investors in our coast and have been. We don't need lawsuits or we don't need to sue them into supporting coastal restoration efforts. They already do. And ironically, every dollar that is spent on a lawsuit is a dollar that is not spent on coastal restoration efforts. Under the Gulf of Mexico Energy Security Act, Louisiana, received more than $150 million in 2023 for coastal restoration and wetlands protections efforts. That funding is directly tied to production efforts, not legal fees. So there, it is clear that litigation has had no, positive impact on Louisiana's coast or Louisiana's coastal restoration efforts. But it is, while safe and responsible energy development has played a very key role for decades, and will continue to play a key role moving forward. And so I just didn't want to leave you and our audience today without really underscoring, the point that there is lots of work taking place to address the systemic coastal restoration issue, not because of these lawsuits, but in spite of them.
I think that's a great way for us to pivot to our last sort of 90 seconds for each of the panelists to give a closing last thought and important insight that you'd like leave the audience with. So why don't we go to in reverse order and go Michael and then Mike and then James.
Sure. So kind of building on what Melissa just said, I think it is important to recognize that not all environmental litigation is wrong. Not all environmental litigation is improper. And environmental laws and regulations are an important part of our state systems. And I'm not suggesting that all of those cases belong in federal court. I think what's maybe most unusual about these cases is twofold. One is just the retroactivity. And as a result of that retroactivity, you're really placing judges in the position of policymakers. They're having to kind of write these liability standards on the fly and then impose them years after the fact. And that's a challenging task for anybody, and it's just not consistent with our constitutional system, especially when you're talking about regulating conduct outside the state's borders. And two, I think there's a real concern just with the simple scale of what's being done here. When you have one court in one county or one parish, tackling a problem of this scale, not identifying or not trying to redress a specific injury, but really trying to engage with a societal problem, an institutional level problem. That's just not what courts are great at. So it creates real complications like you've seen play out in Louisiana. So it's those sorts of reasons that we got involved in this litigation, and it's those sorts of reasons why we've voiced some concern, I guess, about what's happening.
Mike.
Yeah, I would definitely echo what Michael just said about retroactivity. I think that's a key part in a lot of these cases, not just the land loss ones. And the fact that it's a problem in that the courts typically don't like to engage on it unless it's like criminal retroactivity, right? And so the fact that the Supreme Court is looking at this issue and simply by virtue of doing that, drawing attention to this retroactivity problem, I think that that's important not only for this case, but for other cases going forward. As I said before, I think it's really good that the Supreme Court is looking at this, even though it is an oil and gas climate adjacent case. These are big problems that are going to be, the lawfare on this score is a big problem that's going to be, the country's going to be facing, and the court's going to have to address it sooner rather than later. And so it's good that they're starting to do that. And I guess my last point is, it's really encouraging if you look at the Supreme Court docket on this case and see the kind of support that is being given to the right side here. States like West Virginia and their allies, the Solicitor General coming in very strongly in support of Chevron here, of just wide array of good sort of consequential allies coming in, such as General Barr, Judge Mukasey. It's good to see that in this kind of case, and I think it's important because perhaps not as much so in Louisiana, but the broader climate lawfare issue is it is a well-oiled machine with a very strong network in favor of it from states, localities, nonprofits, you name it. And seeing a good group come together in opposition to that at the Supreme Court in this case, I think is an important first sign for where this is going to be going.
And James.
Thank you so much. I think that as we've talked about the Louisiana story here and the exemplar from this case, unfortunately, reveals multiple different areas of due process concerns. We have not just kind of the contingency fee lawyer issue and that their incentives may not be aligned with what is actually in the public good. Obviously, Pelican's research shows that this is not in the long-term public good of the state, even though it may be beneficial to these particular lawyers who are getting their fees shifted. And not just that, but the kind of public policymaker and decision makers who should be looking out for the public good, ceding control through these joint prosecution agreements to those fee shifting lawyers creates kind of a perfect storm, which is something we don't like to see in Louisiana, and we do every few years. It creates a perfect storm of due process concerns here that shows why, in this particular case, these sort of private efforts at enforcement are not what we need. When the regulators in the state basically ceded control to these outside lawyers who stand to gain when the people of the state don't. So we have a perfect storm of due process here, and fundamentally, we believe that this is not the right approach for Louisiana and not the right approach for the rest of the nation, as it is spreading throughout the states.
And Melissa, I think you gave us your closing insight, but any last thoughts?
It was beautifully stated, so I will let that be the final word.
Excellent. Well, thank you all so much. I want to thank our panelists for providing us with this perspective on the overall climate for these cases down in Louisiana, and we will all be watching what the Supreme Court does in the Plaquemines Parish case going forward, and perhaps reconvene once we see that decision at another time.